Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh, and a very good morning. This is a recorded lecture for week 4 topic on the defenses to intentional torts. So this lecture is a synchronous lecture where you will get the recording through the link that I have shared with you on the WhatsApp group. So for today's discussion, I will be speaking on the defenses to intentional torts. So when we talk about the defenses, as you know, that when the case has been proven by the plaintiff, the task of the defendant is to come up with the defenses or counterclaim. In the case of a civil lawsuit, the defendant's task is actually to challenge the case brought by the plaintiff. So over the past 3 weeks that we have done on various types of trespasses, trespass to the person, trespass to goods and land, and trespass to other intentional torts other than trespass, right? So there are several possible defenses that the defendant can rely on or can invoke in order to challenge the case brought by the plaintiff. So first type of defense here is consent. So when we talk about consent, here the defendant can argue that he should not be liable to the act of trespass because the plaintiff have given consent upon it. So the consent here can be given either in express or implied form, or in fact by gesture or by conduct. And of course, if you talk about consent, if it is said expressly, it's much easier to derive or to infer the consent of the plaintiff. But if it is said impliedly or by conduct, that means you have to look at the situation of the case. And if you think from the context of evidence, for instance, you need to have testimony of people who actually can support the evidence of or the arguments, the defense of the defendant that the plaintiff has given consent impliedly or by conduct. So that's what we call as circumstantial evidence, okay, where the defendant can actually brought to the court and prove that the consent has been given. In the case of Freeman and Home Office number 2, the court said that if the consent is not clearly expressed, you can still infer consent by conduct. And in this event, this is what we call as when there is a consent, that means the plaintiff has agreed not to cause the defendants liable or fully liable or totally liable for the act of trespass. So here, the other terms that we use for consent is voluntary and fit injurious. Right. The consent that the plaintiff give here must be done voluntarily and not under duress. So when you want to say that the consent has been given voluntarily, that means there is a free consent or informed consent of the plaintiff. So when the plaintiff gives consent, the plaintiff must understand the nature and risk of the consent. So for instance, in the case of trespass to the person, when there is actually the plaintiff is put under arrest or in a confined room, for instance. So the plaintiff understands that the defendant has done the act based on his consent. And the risk here could be the risk of not, I mean, if we're talking about the case of forced imprisonment, the risk or the consequence of not being able to move around or to get out from the place until all the necessary information is given to the defendant, right? And the consent must be the consent to the act that was complained of, not something else. For instance, if X allows Y to enter X premise, this does not mean that Y has consented to be falsely imprisoned by X. So the reason, the fact that there is actually a permission for Y to enter X premise does not mean that Y also agree that he or consent that he would be falsely imprisoned by X. So the defendant must understand what is the consent for given by the plaintiff. Right. Let's talk about more specific context of consent in the case of medical treatment. In the context of medical treatment, there can be several situations where you can actually argue that the doctor has committed trespass. And remember, we have discussed medical negligence in the context of consent as well, informed consent. But here we are talking about trespass in the case where the doctor did not seek the permission or consent from the patient in carrying out the medical procedure or surgery, for instance. Yeah. So there are several situations here where we can actually look for whether the doctors would be liable if they carry out a certain act in the following situation. The first situation is that what if the doctor fails to explain the nature and consequence of the medical treatment? So in this event, basically, whenever you see the doctor must give you all the necessary information and details. And if you need to go to the next medical treatment, for instance, to recover or to heal the sickness, the doctor must inform you, must tell you all the necessary information about what you will be facing and the effect or the consequence of the treatment. So if the patient did not give consent to the act of the doctor and the doctor still proceed with the medical treatment, that can be considered as a trespass or battery in particular. So this was decided in the case of Chatterson and Gerson. How about the situation when the doctor needs to decide, the second situation here, where the doctor needs to decide on what to do with the patient, or the treatment is necessary to the patient, but the patient is in unconscious state. The patient is not able to give consent here because of the unconsciousness. So here the doctor, as you can see here, that the doctor cannot perform a surgery if the patient has not given a prior consent. So if there is a prior consent before he fall unconscious, that is much easier. But what if at the time when the treatment is needed, the patient is no longer conscious? So can the doctor proceed with the treatment or not? So in this event, generally speaking, if there is no consent given by the patient, the doctor cannot perform the surgery. The doctor cannot continue or proceed with the treatment. If the doctor does so, that can amount to a battery, right? However, the doctor can rely on the defense of necessity. When you talk about defense of necessity that I will be speaking in a bit, necessity is a defense where you can actually rely on when there is a life-death situation. So in the event of medical treatment, if the kind of medical treatment or surgical procedure the doctor is proposing to the patient needs to be carried out, otherwise the patient may be left in coma, for instance, or may be suffering a possibility or potential of death or serious injury if it is not properly treated at that point of time. So the doctor can actually treat the patient even though no express consent is given by the patient. Alternatively, you can still seek consent from the family or from the authoritative person given under the law. However, if there is no one being able to give consent on behalf of the patient, the doctor can actually proceed the treatment even though there was no consent given by the patient in the first place. Please have a look at the case of VT, adult refusal of medical treatment. The third situation here is that what if the treatment is so necessary, it involves life and death situation, but the patient has expressly given an objection or disagreement to the treatment, and the refusal or the objection here can be on the ground of religion. For instance, in the case of Jehovah's Witness, for instance, where they do not simply accept the blood transfusion coming from the non-Jewish. So in the US, they can actually refuse to the treatment if they found that the donor of the blood donor actually does not come from their community. So if the doctor, even though the doctor finds that the blood transfusion is very critical at that point of time, but there is no source of blood from their Jewish community, and the doctor still proceed with the treatment, the doctor could be fined liable under battery. The same thing when the patient has, ethical disagreement if the medication or drug contains animal origin. So the refusal by the patient must be respected on that event, even though the doctors has the right medical decisions to save the life of the patient. But regardless of whatever a doctor does, eventually the consent of the patient is the ultimate, is the highest value that the doctor must conform to or must agree before they can actually carry out the medical treatment. Right. What about in the case of minor? Can they refuse the medical treatment? Well, in the UK, there is actually a different kind of age limit or minimum age requirement who can actually give consent. In Malaysia, we do not have a specific requirement about who can actually be considered as an adult, except in the case of age of majority where you have 21 years old. But in respect to the specific medical treatment consent, there is no specific provision, unlike other some jurisdictions. So what is actually the mature age of giving consent? Is it 16 or 18 or 21? So at common law, we have 16 years old as the mature age to give consent based on the case of Gilead's competence. And then you have under Malaysian law, 18 years old. Basically under various law, you can refer to the Child Act, for instance, to Child Act 2001 on the age of maturity or age of maturity for that respect. Right, so how about the consent of minor in the case of medical treatment? What is the minimum age where they can actually agree and disagree to a medical treatment? Right. The general rule is that minor can give consent if the minor understand the consequence of the treatment. So that's the basic rule. The case of Gilead and West Norfolk Wisbech area of authority here gives us more explanation about when or how the minor can refuse to the medical treatment. In this case, Lord Fraser has given us several guidelines. The judge said that the doctor can proceed with the treatment even though without the patient consent, based on the minor's consent or refusal to medical treatment, provided that in that case the minor understand the advice of the doctor, although at that time the patient may be underage, below 16 years old, because in common law the minimum age to give consent to medical treatment is 16 years old. But if any situation where the minor's age fall below 16 years old, but as long as she or he understands the advice, the treatment given by the doctor, the proposed treatment that will be given by the doctor, that's good enough to say that he or she understand the advice of the doctor. So secondly, where in the case of the minor here, where he cannot persuade her to inform her parents or to allow him to inform the parents that she is seeking contraceptive advice. This is the case where, in the case of reproduction, where, for instance, where the minor has been involved in, some sexual intercourse, and they are seeking contraceptive advice. So in that event, they can actually make their own decision without consulting the parents. This is where they can actually decide on their own whether to continue with the pregnancy or to abort the child or to go for abortion, right? And the other situation or factors that the court can consider is when the minor is very likely to begin or to continue having sexual intercourse with or without contraceptive treatment. So on the issue of reproductive issue among the minors, among the youth or teenagers here, the minor can actually give consent on their own. In fact, refusal for any possible treatment that they would like the doctors to do in the future. All right. Unless the contraceptive advice given by the doctor can actually affect the mental and bodily health of the patient. It could be either one or both of the effect on the minor itself. If that happens, then that would be quite difficult just to rely on the minor's consent per se. They still need to consult their parents. And the patient finally, the minor also must be able to understand what is the best interest of this treatment to them without parental consent. So they must be able to understand the nature and consequence of the treatment, particularly in the case of contraceptive advice. What about the case in Malaysia? I mean, in the UK, where they really recognize and celebrate, the freedom of a child, particularly when it comes to contraceptive issue. But in Malaysia, we may have a significant different context here. So if we allow the children to do that, it can have some social or cultural context here. So in Malaysia, a minor who is between 16 to 18 years old technically may give consent to surgical, medical, or dental treatment. However, there is no precedent yet in Malaysia. Therefore, if you go back to the principle laid down in Gilead's case, the doctor must be satisfied that the patient or the child understand about the nature and the consequence of the treatment. But some treatments may be just a routine treatment where it does not require the presence of the parents. So even though you do not consult the parents because it's just a routine medical procedure, it still can be considered as a valid or informed consent given by the minor. However, if the treatment is somehow a very serious treatment, it can lead to serious injury or complications to the minor, then it could be very unlikely for the doctors only to rely on the minor's consent or minor's refusal to the treatment, meaning that the parents must be there in order to give the absolute or final consent to the child or refusal to the treatment on behalf to the child, because the minor is still considered as incompetent person to give consent, particularly when it involves a serious and important medical procedure that can involve kind of life and death of the child itself. So while you can actually refer to Gilead's case as a guideline when it comes to the consent of a minor to in medical treatment, we have to consider the cultural or social context in Malaysia. Right. Moving on to the next defense is necessity. So here we must be able to understand the difference between the defenses of self-defense and also defense of property. In the case of self-defense and defense of property, it applies. In the case of it applies to necessity in the case of self-defense or defense of property is when the act of the defendant is done for the purpose to protect the self of the defendant, okay, the defendant himself or the property, to protect the property. However, the necessity defense that we are talking here is actually different from the defense that I mentioned just now of self-defense or defense of property. The defense of necessity here involves when the defendant is put in the case of life and death situation, or what we call as imminent peril. In the case of Southwark London Borough Council and Williams, the court held that the defendant, when they rely on the defense of necessity, they must show that the great danger is imminent and the act done by the defendant was for the purpose of saving the lives of the defendant himself. So it is justified in that sense. But you must be able to prove that or justify that the act of the defendant was done on the ground of saving the life of the patient because of the seriousness, because of the grave complications or effect of the defendant's act that can lead to death. So here, there are two categories of necessity. The first one, we're talking about, we'll be talking on the private necessity, and the second one is on public necessity. So private necessity here, when the defendant rely on private necessity as a defense here, the defendant must be able to show that his act, the purpose of his act is justified to prevent greater damage to himself, another, and also property. This is an absolute defense, meaning that once the defendant has successfully proven the case of private necessity, that means he can be totally absolved or escape from the liability. In other words, in short, he won't be liable at all to the plaintiff. However, in order to succeed on this defense, the defendant must be able to show that the act was reasonable. So we have several situations here when the defendant or how the defendant can actually use the private necessity as a defense. The first situation, can the defendant use the defense when his life was put under threat or in a in peril, in an imminent situation, or when his life is at peril or at you know, his life is very is very exposed to the risk of death, for instance. In the case of Scott and Shepherd, the court said that what happened in this case was the second and third person threw lighted squib but hit the plaintiff. The court held that the defendants were not liable because they had acted under a necessity to protect their own safety and life. Well, sometimes when you are put in life and death situation, you have not much choice except to act in a situation that can injure the plaintiff. But the act may be justified if the act was for the purpose to protect the safety or the life of the defendant. But when the plaintiff was injured because of the defendant's act, it must not cause, you know, another death to the plaintiff itself. So it must be somehow, you know, a reasonable act where the plaintiff will be injured, but reasonable or proportionate to the act of the defendant. The second case here is the case of Lay and Gladstone. In this case, the plaintiff, a women's rights activist, was imprisoned. She made a hunger strike. The warden force-fed her to save her life. In this case, you can see that there was actually you know, a trespass to the person here, but where the warden force-fed her to save her life. However, the court said that the act of the prison warden was justified because the intervention was necessary to save the life of the plaintiff. How about the case when, I think this is coming back to the earlier defense, when on the defense of consent to medical treatment, where the issue here is whether the doctor can perform a medical treatment when the adult refused. Just now we're talking about the minor. Okay, what about the case of competent adult refused to the treatment? In that case, that can amount to battery if the adult is a competent adult. Competent adult means they are able to give consent, they are not unconscious. But if they are unconscious and the doctor feels that it's very critical for the doctor to carry out the medical treatment to save the life of the patient, it is lawful, it is justified to do so. Right, what about the act of private defense of necessity in the case of protecting his own property? In the case of Cook and Sharp here, the fact of the case was there was a fire caused on plaintiff's land. The servant of the plaintiff tried to remove the fire, extinguish the fire, but the defendant who had a shooting right over the plaintiff took necessary steps to set out fire and protect people from the fire. But the fire has actually gone onto the plaintiff's land and caused damage to the plaintiff's land. So it caused a trespass to land here. The court held that the act of the defendant was justified because it's very important for the defendant to do so, reasonably necessary, so that it could avoid the risk of death to the persons involved there. Right. So in the case of, if you compare the case of Cook's case, where the court said that the act of the defendant was reasonable for the purpose of saving the fire, saving the life of the people in the situation. But in the case of Southwark's case, even though the act was justified, but the court said it was not reasonable because the defendants was squatters. So in-laws, squatters had no right. So they had no, locus or justification or basis to do so because they had no right in law at all. So the defendant was still liable for that. How about the situation when the defendants diverts potential injury to his land to the plaintiff's property or land? This is the situation I think we have discussed previously in this case, yeah, for the purpose of protecting his own property. This is the case where the defendant does something to escape the injury, to escape the fire, but the fire has actually trespassed to the plaintiff's land. So in the case of Whalley and Lancashire and Yorkshire Railway Company, the defendant here deliberately diverted the water flow. This water subsequently flooded the plaintiff's land. The court held that the defendant's act was justifiable because piercing of embankment here was not ordinary use of embankment. So the diverting act of water there is justified for the purpose of, avoiding a larger flood or more grave flood to the properties among them. However, we have to contrast the situation in the case of Gray, Weinstein, and Hatting. In this case, the defendant diverted locusts from entering the land. So it enters the third party's land and went onto the plaintiff's land and destroyed all his plants. The defendant was not liable in this case because the act was actually to protect his property. So how do you actually compare the situational decisions in the case of Whalley and Gravenstein just now? So think about it on why the court in this case held that it was justifiable, and this act as well, the court find it justifiable for the purpose of protecting the property. But there was some difference decisions decided on this particular two cases. Please have a look at the details later. Secondly, the category of necessity here is the public necessity. In the case of Dewey and White, the court looked at the situation when there was a fire here, where the defendant threw down the plaintiff's chimney. The defendant was held not to be liable because he was saving the fire from spreading to the highway. So in the case of public necessity, what you would do is basically to weigh between public and private rights. So sometimes public rights is, in the case where you see the clash between the two, public rights or public necessity would prevail over the private ones. So like what happened in this case, the defendant was not liable because he was saving the fire from spreading to the highway. And even though it caused damage to plenty, but it was necessary to do so to prevent a greater damage or evil to the public space, which is the highway, or which was the highway here. Right, next defense is mistake. Mistake is not a good defense, by the way, either mistake of law or mistake of fact, unless you have necessarily shown that necessary step has been taken and mistakes still happen. So that could be a good defense, but it's not an easy defense to do. But once the defendant can successfully rely on the defense, it could save the defendants from liability in trespass. In the case of Consolidated Company and Curtis, the court in this case held that an auctioneer was liable in conversion to A when he sold off A's good, albeit in the honest and reasonable belief that those goods belong to B. Well, this was the case, remember, where we discussed about the bona fide purchaser. So even though in the case where there are competing claims, where the real owner or the legal owner comes to challenge on the ownership and they want to claim back the return for the goods, they have to return. Otherwise, it can be a case of conversion because the goods has been sold to a bona fide purchaser. The bona fide purchaser can actually be sued under conversion, even though during the time of the selling and buying transaction between the plaintiff and defendant, it was done in honest belief that the goods belong to the defendant because the defendant represent themselves as someone who has the authority to sell the goods. So the defense of mistake here is not successful. Right, next defense is inevitable accident. Here, the defendant must show that the accident has occurred despite having taken reasonable precaution at all material times. You can take the example, for instance, in the case of accident. Sometimes when you are on the road and facing unexpected situation where you have no choice except to avoid the accident, where when you try to avoid from the accident, it can possibly cause injury to the other road users. So this is what we call as inevitable accident. The court in the case of Farden and Harcourt-Rivington said that the burden of proof lies on the plaintiff. Once the plaintiff has proven that the act of trespass was intentional and voluntary, so the defendant has no defense of inevitable accident. So it is still a difficult defense here on inevitable accident, but it could be possible defense for the defendant to use against the plaintiff. But once the plaintiff has proven the defendant has trespassed the land or has trespassed the person intentionally or voluntarily, the defendant has no right to rely on the inevitable accident. Remember when we talk about the issue of transfer intent in the case of trespass to the person. So the plaintiff can actually rely on this defense of inevitable accident when, for instance, the defendant tries to hit the plaintiff, but instead the defendant accidentally hit another person or third party. So in that situation, the defendant technically would still be liable if the plaintiff has proven that the act of trespass is done intentionally and voluntarily. Remember, in trespass, we refer to the act of trespass itself, not to the intention whether he has intention or not to hit the defendant. But if it was an inevitable accident, so the defendant can rely on the defense of inevitable accident, provided that the plaintiff has not proven the case successfully on trespass. The next defense is self-defense, defense of property and defense of another actually rely on the same general rule. So let's first talk about self-defense. Self-defense is a defense of himself, a defense of the defendant himself. For instance, when the defendant is being attacked by the plaintiff. So self-defense is a good defense for the defendant to defend himself, where he should take that step to defend himself from the injury or from the physical contact. From the anonymous case, the court said that in order to apply self-defense, two requirements must be satisfied. Number one, the question that we have to ask is whether it is still reasonable for the defendant whether it is reasonable for the defendant to use violence in defending himself. And secondly, if the defendant has defending himself, then the act of defending or the act of violence is actually proportionate to the plaintiff's act. So there are two requirements here: that defendant's act must be reasonable and also proportionate. Sometimes you have reacted to act, but the way you react is actually too much to the plaintiff, so it's not proportionate, so you cannot be successful in this defense, right? So the case of Lane and Holloway here is a good illustration on when this self-defense can be successful. In this case, the plaintiff was 64 years old and the defendant's age was 23 years old. So you can see the age difference here. The defendant's wife put rude words to the plaintiff as he was walking back to his house. The plaintiff replied likewise. So there is, there was an exchange of words or between them. And it actually led to a more serious encounter between them where the defendant challenged the plaintiff to fight. As the defendant walked towards the plaintiff, the defendant thought that he was going to hit the plaintiff, but the plaintiff hit the defendant on the shoulder. So the defendant retaliated by hitting the plaintiff and caused him to suffer injury, which caused him to have 16 stitches. The court held that the act of the defendant was not proportionate to the plaintiff because looking at the age of the plaintiff, 64, well, the plaintiff should, the defendant should have just tolerated on what the plaintiff's done. So the violence here was not reasonable and proportionate. Therefore, the defendant was liable for the battery. Right, defense of another, as I said just now, we use the same rule like the self-defense. And in this situation, in this defense, the question here is, can the defendant act reasonable if he used extra or greater force to defend another person like a family member? As compared to, I mean, the defense of another here can be a defense of family member or a defense of just a stranger. So here, in relying on defense of another, the court will look at who the defendant is defending. Is it he is defending a family member or a non-family member or a stranger? Because that makes a sense for the court to see whether the act was reasonable or proportionate enough. Right. The case of defense of property here, where the defense can be raised when the defendant has the position of fact or position in fact or right to immediate possession as against trespasser. So this is the case when, for instance, in the first case where possession in fact, where the defendant has the possession in fact, a factual or physical possession. Imagine in the case where the defendant was a tenant and the plaintiff come into the house without the consent and the defendant attacked the plaintiff and there was actually a fight between them. So, and because of the defendant did not pay the outstanding rent, so the defendant can rely on this because they have the possession in fact or physical control over the property because they paid they live as a tenant there, right? Okay. In terms of the right to immediate possession, this is when the case where when you say right to immediate possession, when the plaintiff buy the land, okay, but did not get the official or land certificate. So once he had bought the land and they have actually come onto the land, they have the right to immediate possession to avoid any trespasser from coming into the land. Either they want to commit trespass by entering into the land or planting the plant without the consent of the defendant. So they can actually rely on the defense of property for that reason. In the case of Holmes and Bache, in this case, the plaintiff was forcibly removed from the cricket field by the defendant's direction. Defendant's defense was that he had possession of the field, but the defense was dismissed because the club actually had the possession in fact of the club committee has the possession in fact for the club itself, right? So in the case of defense of property here, the question here is that can it be a trespass to land when the defendant used a reasonable force to remove trespasser? You have in the case of trespass to land here. In the case of Collins and Ranison, the plaintiff placed ladder in the defendant's garden without permission and climbed to his own roof. So defendant asked the plaintiff to climb down, but he refused. The defendant shook the ladder and the plaintiff fell. In that case, the court held that defendant's conduct was reasonable but unwarranted, meaning that unjustified or not proportionate. Therefore, the defendant was liable for his act. What about in the case where the defendant used greater force when the trespasser come onto his land and take away his good? This is the case where you can actually combine the act on trespass to land and trespass to goods against the defendant. So when the defendant come onto the land, when that happened, the case of Depu and Plato here can actually be a very good guidance for us to decide whether the defendant will be liable if they are avoiding the trespasser from coming onto his land and take away their property or goods. In this case, the court held that the occupier, like in the case of tenant, the lessee, and toll holder, for instance, they could be held liable if that happened to them. As someone who has possession, in fact, he cannot do indirectly or by mechanical device to remove the trespasser because this could cause bodily injury to the latter. So if to answer that question or scenario here, the defendant cannot use extra or greater force to remove the trespasser from the land or from taking away the goods from the defendant's property. So we're talking about the use of force here. How much force is considered as reasonable and proportionate for the defendant to use against the plaintiff? And what would consider that defense of property here is reasonable for the interest of saving, the defendant's safety and also the property of the defendant himself. So the court said that when someone who has possession, in fact, or immediate possession, they can use force, but the right of the defendant to use force here is not absolute. Therefore, the use of greater or extra force against the plaintiff may not escape the defendant from the act of trespass against them. It must be used reasonably. This was decided in the case of R. and Chief Constable of Devon and Cornwall. The court said that if the defendant would like to use reasonable force, they must do that reasonably. They must do so according to the statutory duty. If they are subject to statutory duty, for instance, they want to confiscate a certain material from the defendant's property because the defendant did not pay the outstanding rent or outstanding rental or outstanding payment of fees. So they want to confiscate under what they call as a distress order. Okay. They can do so, but not for the purpose of using unreasonable force against the plaintiff, even though they have right to do so, but it must be done. This must not be done unnecessarily. Okay. Contributory negligence, this applies to as trespass to the person. So as you see here, in the case of Murphy and Calvin, the husbands of the plaintiff was assaulted and killed by the defendant. So in that case, the defendant was guilty of manslaughter, of culpable homicide. The same words actually. To refer manslaughter is an English criminal law word, and culpable homicide is provided under our penal code. The defendant argued that in the case of civil action of assault, it was the defendant's own fault that has contributed to his own death. The court said that regardless that the plaintiff has, regardless the defendant has admitted to the criminal act of manslaughter, the defendant still can raise the defense of contributory negligence to escape the liability in the case of assault. So there are basically two different lawsuits here, one in civil action and another one in criminal prosecution. So even though the plaintiff was found guilty as well by the court of manslaughter, the defendant still can argue that the plaintiff's death was actually contributed by his own negligence. So on that basis, the defendant has succeeded in the civil lawsuit on contributory negligence defense. Right, next defense is discipline. This is very much relevant, particularly in the case of battery and forced imprisonment. So in the case of discipline by parents, for instance, yeah, it is justified as long as, you know, reasonable way of doing that by the parents at all time. The same thing in the case of school teachers. So there are certain regulations at the school where the teacher could not impose caning on them. There are many ways of disciplining them, but if there is a clear prohibition that is prohibited to discipline the students in a particular way, then the teachers or the warden or the supervisor of the school should not do that. So as I mentioned here, that it would depend on the school rules and also parental instruction. So if there is any like a guidelines or a prohibition, then the school teachers are bound by the statutory duty. That's why we call statutory duty, because there is a guideline over there. Okay, but of course there can be more discussion on this for the details. All right, in the case of Ryan and Fielders, the plaintiff was 10 years old, was boxed on the ear by his schoolmistress for the lack of discipline. He became deaf in 1 year. The court held that the act of the teacher or mistress has exceeded the reasonable and lawful correction. So even though he has a right, the school mistress has a right to do so, but the act was unreasonable and unlawful. Right. In the case of passenger in public transport, this is the case when, in the case where someone actually on board goes on the public transport without paying the fee, or so in that case, the conductor or the station manager, for instance, can remove the passenger from the station to discipline them. But reasonable force can be used. If there is any unreasonable or excessive force being used, then there could be an act of, you know, there can be, the discipline act was not enough, therefore there can be an act of trespass in that sense. Lawful arrest, this is applicable in the case of battery, forced imprisonment, and trespass to goods. So basically, lawful arrest is done by the citizen or by someone who has an authority. If someone who has an authority, like a police officer, they can actually carry out an arrest without warrant if they suspect that the person has committed a seizable offense. So seizable offense is provided under the Criminal Procedure Code. So the authority to carry out or to conduct arrest here is provided under Section 23 of the CPC. And then you have this what we call citizen arrest under Section 27 of CPC, where someone who has authority as well can actually arrest a person and take him to the nearest police station without delay. And a private citizen, if you're a public, for instance, then you suspect that there was a crime committed by a suspicious person, you can arrest them. Either it is seizable or non-seizable offense, you have the right to carry out a private citizen's arrest, and provided that it is done reasonably and proportionately to the act while waiting for the police to come and arrest the person. All right, the defendant also can actually rely on the defense of statutory authority or statutory duty here. So in the case of, I give you one example here in the case of trespass to land, where the right to fly an aircraft is actually a right to use the airspace, a right to use and enjoy the airspace. So in Malaysia, we have the Civil Aviation Act 1969 and Section 19, where the aircraft owner would not be wholly liable for damage if the landowner has incurred by negligence or contributory negligence. If you're talking about this, particularly when the damage is caused by the aircraft owner flying above the airspace of the landowner, if there can be suit under trespass. However, if the accident happened because of the negligence, then they would not be totally liable for that. But if the landowner has actually committed negligence and or contributory committed to the negligence, the aircraft owner would not be totally liable for the damage or trespass to land here. Right. So if the act was authorized by the statute, that means there shouldn't be any issue of act of trespass. The last one is Jus 30. In this case, where the defendant contends that the plaintiff's claim against him ought to fail on the ground that a third party has a better right over the land or goods than the plaintiff himself. This defense does not apply to trespasser unless the defendant has acted on the authority of a third party. And the last defense, that was the second last just now, acts the precaution in order to act show. In this case, in this defense, it means the court ought to enforce an illegal contract or allow, the court cannot enforce an illegal contract or allow it to enforce obligations that coming out from an illegal contract. So here, the court cannot assist the plaintiff who has been found guilty of illegal or immoral conduct. In the case of T. Kian Ho and Kewangan Bersatu, in this case, the defendant has let out some tools for furniture making on hire purchase to a company X, which is a spray pump here. So they actually they get the spray pump on and on hire through a hire purchase transaction. So X has defaulted the monthly payment. So because of the default, the defendant needs to repossess the pump, but the pump was not found on X premise. Instead, the defendant repossessed from an adjacent factory owned by the plaintiff. So in this case, the court said that the plaintiff was an alter ego of X and taken over X premise. So the claim of the plaintiff against the defendant on trespass was dismissed because he was supposed to return the spray pump here, which he had hired from the defendants. The court held that, and in fact, the court held that the plaintiff's conduct was a conversion of his own gray pump because he has used the goods without the consent of the defendant. All right, that's all for today's lecture today on the defenses to intentional torts. If you have any questions, please feel free to ask me or come to me for consultation. Okay, thank you so much, everyone, and have a good day. Assalamualaikum warahmatullahi ta'ala wabarakatuh.